and founder of Medical Justice. A little bit of my background: I'm a board certified neurosurgeon, also went over to the dark side, so I'm an attorney. In between, I practiced in a biotech firm, and I spent a lot of time chatting about professional liability issues as well as assaults on reputation, in particular online. We also manage a host of other thorny medical legal challenges, for example, complaints to the Board of Medicine and the National Practitioner Data Bank, and so on and so forth. So today we're going to chat about, can I sue my patient for defamation? Can I tell you the number of times I received a phone call? I'm angry, I'm mad, my patient said something horrible about me. I want to sue them, and I want to sue them bad. Not uncommon. All right, so imagine this review. Dr. Segal sucks as a doctor. I'd give him 0 stars if I could. He needs to have his license revoked. Is that flattering? No, it is not flattering. Is it ugly? Yes, it is ugly. Is it legal defamation? Is it legal defamation? The answer is probably not. I know that's not the answer you want to hear. And should you sue the poster? Well, if it's not legal defamation, there's no great reason to sue the patient because likely you will lose. And in some states, not only could you lose, but you may get stuck with the other side's, the patient's, legal bills. That would be a worse than level outcome. All right, so let me start out. We live in America. You can sue for anything. There's no hard rule that you can't sue someone alleging defamation, but by and large, you, the plaintiff, will have to prove defamation. So if you want to win, you should at least know what are the characteristics, what are the elements of a claim for defamation, and if so, will you have a case? So what is defamation? Defamation is a false statement made to others which damages your reputation. Let me repeat that. Defamation is a false statement made to others damaging reputation. Okay, dig a little bit deeper. False statement. Well, if it's true, it's not a false statement. So truth is a pretty good defense to an allegation of defamation. Number two, if it's an opinion, it's not really a false statement. An opinion, is something that you have as an individual, but different opinions can be held by different people. A false statement is not a true statement. A false statement is not an opinion. Actually, let me go back. I want to give an example of this. So in the original example, it said Dr. Segal sucks as a surgeon. That's an opinion, okay? It's not a false statement. It's an opinion held, presumably held by the individual that posted it. But let's say that someone wrote, Dr. Segal is not board certified. Well, it turns out I am board certified, and that's demonstrably provable as a true or false statement. So if someone were to write, Dr. Segal is not board certified, in point of fact, I am board certified, and they post it to others, and arguably it damages my reputation, that would meet the criteria of a false statement with a valid claim for defamation. So I hope that gives you an idea as to what is the difference between a false statement and an opinion. Okay, defamation also must be made to others. It's a false statement made to others, either written or spoken. But if it's just a letter that somebody wrote to you that said, you, Dr. Segal, really suck. And let's take this example a bit further. It said, for your eyes only, private and confidential. Well, that's not really defamation. It's a statement that was made to you and nobody else. But for it to be defamation, that statement must be made to others. And then finally, it has to damage your reputation. Let me give you a counter narrative. There's something called a libel-proof patient, not in every state, but in many states. A libel-proof patient means that you already have such a horrific reputation, it really would be hard to damage it further. Meaning that it doesn't matter what I say, you've already damaged your own reputation so much. So, for example, could Harvey Weinstein sue for defamation? It would be pretty challenging because he's already damaged his own reputation. I know it's a moving target, and at the time I'm recording this, he may be going back to court, but I would argue for the most part, his reputation is already quite poor, and it would be very difficult for him to prevail in a lawsuit of defamation. All right, so a lawsuit in defamation, there's you've got to demonstrate that your reputation was damaged, and you may actually have to prove damages. So how can you prove damages? Well, to the extent that you run a business and that you are bringing in, let's say, $1 million a year, if based on a patient statement, you can now demonstrate you're only bringing in $500,000 a year, well, you have some you have a hard number. You've got $500,000 in net damages. Is it attributable to the damaging statement? Maybe, maybe not, but that certainly would be helpful. But just remember, if you're ready to pull the trigger to go to court with a case on defamation, the question is, have you really been damaged? You may have to show your tax returns, and that may be Exhibit A. So, for example, if your business went up, in my example, from 1 million to 1.3 million over a year with this nasty Dr. Segal sucks online review, does that mean you've been damaged? Well, I guess anything's possible. I mean, you could certainly argue that you were on track to bring in 1.5 million, but the burden will be on you to demonstrate that you truly had damages. Now, in America, there are damages called, damages per se, libel per se, which means you don't necessarily have to prove the damages. They're just presumed to have caused damages. So this is a bucket of four. There may be others depending upon the state in which you live. So the first one would be alleging you committed a serious crime. Number two, alleging you have a loathsome disease. You can see how old some of these legal theories are. Loathsome disease typically would have been a sexually transmitted disease or something where nobody would want to be around you. So, for example, if you had smallpox or tuberculosis and you didn't have it, that would be a loathsome disease. You wouldn't have to really prove damages. Merely saying you had this loathsome disease would be enough to presume that you've been damaged. Number three, probably relevant in the domain of the medical world, being the allegation being that you're incompetent in your profession. So, in my example, it said Dr. Segal sucks as a surgeon. Arguably, that's a statement that I'm incompetent in my profession. And so, would I have to prove my damages? Would I have to bring my tax returns? Arguably not. Arguably, my damages are presumed. And number four, an allegation that you are unchaste. Again, this is a relic of a different age. I'm not sure it makes much of a difference today as I record this. This would be 2024. I'm sorry, 2025. We're already in 2025 now. But being declared unchaste, I don't know how damaging that may be to one's reputation. All right. So the mere fact that somebody has, or that you have been able to demonstrate that there's a false statement which damages your reputation, that's a good start, but it's not enough. There are defenses that your patient can and presumably will make. Starting from the very beginning, we talked about truth and opinion being two major defenses against an allegation of defamation. If it's truth or if it's an opinion, then it's not really a false statement. The third one is rhetorical hyperbole. Rhetorical hyperbole. And for some reason, judges give patients a pass on the internet with their conclusion being, look, everything you read on the internet, nobody believes that to be totally true. And so if it's a patient saying, Dr. Segal's a butcher, well, I don't really think you're a butcher. They don't think that you've killed a bunch of people, but calling someone a butcher is just calling you a name. And it's rhetorical, it's hyperbolic, it's not really defamatory. Privilege, there are locations where you can say something and get away with it, whereas in other venues you couldn't get away with it. So, for example, if on the witness stand in court, a patient says, Dr. Segal is a pedophile. If he were to say that, and by the way, I'm not a pedophile, but if that individual were to state that online or somewhere else, well, that arguably would be defamatory. But if you state it on a witness stand, you're allowed to get away with some stuff on the witness stand. That doesn't mean you can say anything on a witness stand because you are under oath. And if you state something that is material and is a lie, you could be beaten up or prosecuted for perjury. So you can't always get away with it, but there are some venues we can get away with many things. Next, consent. If you gave someone permission to state something ugly, I can't imagine why that would be the case here, then arguably you don't have a case. And then finally, you don't have forever to make your case. So if somebody's beating you up, particularly on the internet, you can't let it sit. You really need to move on it sooner rather than later. So if they wrote the nasty review 6 years ago, 8 years ago, arguably that ship has sailed. You're not really going to have much ability to successfully prevail in court. Now, it is true that if you've already made their claim and they still leave it up and don't take it down, that there's ongoing defamation taking place. But that's another story for another day. Okay, there are other defenses. If you, the target of the defamatory statement, are a public figure, or if the topic being discussed is a matter of public concern, the threshold is a little bit higher to prevail, for you to prevail, in a claim of defamation. So what is that standard? That standard is malice. Now, it's not malice that, they didn't like you. Malice means something else in a court of law. It means that you have to prove it by clear and convincing evidence that in this case, we'll assume a patient had knowledge that the statement was false, or they did so with reckless disregard for the truth. This is harder to prove. This is similar to a media standard. So if, for example, the New York Times posts something that is false and it damages your reputation, you have to demonstrate that you were defamed with malice, that you will have to prove by clear and convincing evidence that the New York Times either knew it was false or there was reckless disregard for the truth. Now, it turns out that because, if you're a physician and you use the online world to make your practice, if you are very visible on TikTok, if you spend a lot of time doing internet marketing, arguably you are a public figure, which means that if you want to sue someone for defamation, you're probably going to have to demonstrate not just that they made a false statement which damaged your reputation, the statement was made to others. You're going to need to prove it by clear and convincing evidence that the patient knew that statement was false or did so with reckless disregard for the truth. Difficult, not impossible, but just difficult. And if it turns out they knew it was false, so let me go through an example. Let's say that it's very easy to demonstrate whether I'm board certified or not. And somebody goes out there and says, Segal's not board certified. And I can just pull out the document from the American Board of Neurological Surgery demonstrating that I am indeed board certified. Not only that, you can go to is my doctor certified, and you plug in my name and you'll see that I'm certified. So it's very easy to prove whether the statement was demonstrably true or false. So in that particular case, I probably would be able to prove that, even if I'm a public figure or if the topic being discussed is a matter of public concern. These are some of the details. What I'm trying to let you know is that it's not only is it challenging to prevail in a case with defamation as a physician, particularly if you're in the limelight with extensive marketing, it's even harder. Or if the matter being discussed, like surgery in general or something related to public health, comes up, again, it could be harder for you to prove your case and prevail. All right. There's always something. And so just to make matters worse, there's something called SLAPP. And this is SLAPP with two P's, SLAPP, and it stands for Strategic Lawsuit Against Public Participation. So let's say, for example, that you are a wealthy physician and somebody says something ugly about you on the internet. Let's say they write something and say, you're a butcher, you suck, and you have no bedside manner. I'm not sure that it would rise to defamation, but let's say that I decide I'm going to sue you for defamation. If you live in a state that has very strong laws against SLAPP lawsuits, against strategic lawsuits against public participation, they're going to be able to wiggle out of that lawsuit pretty quickly and then potentially turn around and collect their legal fees from you. So let me spend a couple of minutes talking about this. What is a SLAPP lawsuit? That's where you, in this case, the doctor, file a lawsuit alleging defamation against presumably your patient who's speaking out on an issue of public interest or concern. So the patient is arguing, hey, I have a First Amendment right to speak my mind. I'm just trying to educate the public about this menace, Dr. Segal, and I'm not saying anything that's false. It's true, and he's trying to stifle my ability to speak. He doesn't want me to tell the world because he's afraid of the truth. He's afraid that people will find out. So their argument is that I'm abusing the legal system to silence them. The argument would be, my goal is to intimidate this individual so that they won't speak out on an issue of public importance. Strategic lawsuit against public participation, SLAPP. So what's the remedy to SLAPP? Well, anti-SLAPP. And every state treats this differently. Anti-SLAPPs help the target of a defamation lawsuit. In this particular example, it would help the patient who wrote the nasty review. And the purpose of these anti-SLAPP laws are to prevent people like me, the doctor, from abusing the courts to intimidate individuals from exercising their First Amendment rights. So how does it work? The patient, in this case, the individual being sued for defamation, moves to strike the case and then says, look, this is a matter of speech involving a public concern. And the plaintiff, me, the doctor, now has the burden of proving that they're going to prevail. If I can't meet that burden, the lawsuit is quickly dismissed. So, normally lawsuits take time. You have to get all the evidence together. You go through a process called discovery. So it's a long, drawn out, expensive process. But here, if the patient is saying, I'm invoking the anti-SLAPP system, then I have to very quickly make my case, or at least demonstrate I'm more likely than not to prevail. If I, the physician, can't do that, the lawsuit is dismissed. And to make matters worse, not only is it dismissed, but many statutes in various states allow the defendant, in this case the patient, to collect their attorney's fees. So not only do I not win, not only do I not prevail in a case with defamation, I lose, but to add insult to injury, I become responsible for the other side's attorney's fees. So you want to think about that before you just quickly go to sue someone, which means if you're going to sue someone for defamation, you should ask the attorney, tell me something about SLAPP, tell me something about anti-SLAPP. I don't want this just to be a zero-sum game. It turns out that if it's not likely I'm going to win, is it possible that I could lose and actually have to pay the other side's attorney's fees? You want to make sure you ask that question, because if the attorney that you're chatting with says, I have no idea what you're talking about, you probably want to get an opinion from another attorney. All right. So every state is different. Every state has anti-SLAPP laws that are quite different. Let me see if okay. So in this particular case, you can look at the green. The green means that it's very favorable for anti-SLAPP, which means that your patients are more likely to prevail against an act of, if you're trying to intimidate your patient and you don't really have a great case for defamation, the green would be the states where you don't want to file an action for defamation. So California, the West Coast, but also other large states, like Texas and New York, you want to tread cautiously. I live in North Carolina, and while the laws change year by year, it's probably not as patient friendly if I were to try and sue a patient for defamation. I may not win, but I probably wouldn't necessarily be responsible for their attorney's fees. And the case may actually see the light of day. So every state is different. If you want to see how your state prevails, you can just Google state anti-SLAPP law scorecard, and you'll get an updated version of what that map looks like. It may even include the territories if you happen to live in the Commonwealth of the Northern Mariana Islands or Guam, for example. All right, let's spend a couple minutes talking about this famous individual. This is Barbra Streisand, and there's something called the Streisand effect. The Streisand effect has nothing to do with her ability to sing or act. She's both a talented singer and actor, but the Streisand effect is something else. If you go to Wikipedia, the Streisand effect is labeled as an unintended consequence of attempts to hide, remove, or censor information, where the effort instead increases public awareness of the information. So in the example we're giving earlier with SLAPP, if you're trying to prevent someone from posting something online or to intimidate them to take it off, by suing them, if it turned out that everybody learned of this ugly review, not just 10 people, but now 100,000 people learn of that review, that would be an example of the Streisand effect, an example of litigation having the unintended consequence of increasing awareness as opposed to minimizing awareness of the ugly review. All right, so let's talk details here. In 2003, Barbra Streisand sued a photographer who I'm sure almost nobody has heard of. His name was Kenneth Adelman, and his company, Pictopia. She sued him for a mere $50 million. Why? Violation of privacy. What was the deal? Image 3850 was an aerial photograph of her mansion on beachfront property. So I think Kenneth Adelman and his company was either hired or wanted to document public pictures to demonstrate its effect it's having on coastal erosion. Certainly one of my favorite topics. But he had 12,000 photos, or there were 12,000 photos, and he cataloged them in one location, so you could just see what was on the coastline in California. Not a particularly popular website, but Image 3850 was an aerial photograph of Barbra Streisand's mansion. And as you can see from this picture, it is quite a nice mansion. It is a sprawling residence on the coast. I'm not sure I could tell much about whether there's erosion or not. But in any event, Barbra Streisand did not like this picture on the website. So she sued Adelman, but she lost. The lawsuit was ultimately dismissed, and Streisand was ordered to pay Adelman $177,000 in attorney's fees. And here's what's most important about this drama. This image, the one that I'm showing you now, and probably will be viewed by multiple people, it had only been downloaded a mere 6 times before the lawsuit. And 2 of those 6 times were from Streisand's attorneys, meaning nobody knew of this picture, nobody cared about this picture, to the extent it was causing Barbra Streisand any anxiety or it was increasing her head pain. There was no reason because nobody saw it. But right after this became a lawsuit, lots of people became aware of it. Apparently, 420,000 people visited the site. I don't even know if that site is still up, but I can tell you that her goal was to keep anyone from seeing this. And because of litigation, everybody saw it. The Streisand effect. So, how did it get named the Streisand effect? And this is the history. Actually, I didn't know this till I came up with this, till I put together this PowerPoint. So, in 2005, which was a couple of years after this drama, Mike Masnick of TechDirt called this the Streisand effect when he was writing about a resort called Marco Beach Ocean Resort. And well, let me back up. There's a website called urinal.net, a site, you can't make this stuff up. It's a site dedicated to photographs of various urinals. And apparently there was a photo of Marco Beach Ocean Resort's urinal. As to why anybody would be interested in that, I have no idea. If you're looking at the photo right here, it says urinals of a Marco Island hotel and vacation facility. And I don't know, it's hard to tell whether it's good or bad, but this turned into a takedown notice. They apparently had the same anxiety that Barbara Streisand had. And let me back up. So ultimately, this whole drama, the whole notion of using litigation to silence someone, having the counterintuitive effect of increasing public awareness, called the Streisand effect. So we often tell people, said, look, be careful of something that's on page 10 of a Google search turning into a page 1 story merely because you've decided to propel some litigation. Streisand effect. The truth of the matter is that for many of these one-off ugly reviews, to the extent you're getting new reviews, that old nasty review will be buried. It will be deep. It will be forgotten. Most people won't pay attention to it. But to the extent you are suing someone for defamation, that will be the page 1 story. What you tried to silence could very well be the page 1 Google man bites dog story. Streisand effect. Other things that lawyers don't tell you about as you are paying their hourly rate to sue a patient for defamation: time consuming. It's going to be a tremendous time suck. All litigation is a time suck, but this is no less of a time suck. The outcome will often depend upon your judge and jury. You may win. Odds are you will lose, but you may win. My point is that you don't know what the outcome will be. What I can tell you that is not uncertain is that it will cost you a lot of money. If you can find a decent attorney that understands defamation, they don't come cheap. You're going to have to write significant checks to that individual. And remember, even if you win, you may get nothing but a piece of paper. Your defendant patient may not, be a gazillionaire. They may not have assets, and so you may have won the battle but lost the war. They may not even make you whole for the amount you set aside for your attorney. So what do I tell people? I say that, look, if it looks like the defamatory actions are threatening your institution, your organization, existentially, you may not have a choice. You may have to actually go to World War III. So my comment is it's rare, not never, rare. So be careful about just jumping into into litigation for defamation. So how can you get a nasty review taken down if defamation is not the path that I'm recommending? Well, the site can take it down. So if the review violates the terms of use, you can petition the site to take it down. We're quite successful with this many times, actually. It depends upon the site, depends upon the review, but not infrequently, the ugly review does violate the terms of use. So for example, if the patient goes into an expletive-laden rant and the terms of use say, hey, no profanity, that's actually pretty easy. You can get it taken down. Other times, the site will mandate that the reviewer have firsthand knowledge of your care. So for example, if it says, hey, my friend went to see Dr. Segal and he's a butcher, that's not firsthand knowledge, that's secondhand knowledge. So that would violate the terms of use for that site, and arguably you can get that review taken down on that site. Sometimes, if it's not firsthand knowledge, it's related to a cyber mob. You could have been in the news for something that's not great, whatever that is. And then because we live in the online world, thousands of people may jump onto your Yelp profile and decide they have an opinion and they're going to town. And I've seen this type of language used in the past while you're waiting for Google or Yelp or any of the other sites to take action and just shut down the ability of random individuals to post. This one says fake post alert. This person has never been a patient of Dr. Segal nor his practice. We'll continue to flag every fake post, have the accounts reported to Google. In this particular case, it actually was helpful. That it took a couple days for Google to pick up on this, and they removed virtually every fake review. None of those individuals that posted fake reviews had any interaction with that person's practice. It wasn't my practice, it was someone else. But in that particular situation, this helps alert Google to the fact that you got a mob, and the mob clearly has had no experience with the practice. And Google will have some of that information internal. If the practice has only received 6 reviews over the past year and now has received 423 reviews, well, something changed. And that something is almost certainly a news story or something else where the practice was seen in an unflattering light. And here, this type of language can help make your case to Google so that it picks up the baton, takes action, and closes off the ability of new people to post and then to take down the fake reviews that have populated the site. The second way to get a ugly review taken down is that the patient does it him or herself. Those are really the only 2 ways to do it. Either the site takes it down or the patient takes it down. So how do you get that to happen? Well, this is old school. Try calling the patient, listen to the patient's beef, and if you can, solve the problem. I know this sounds like it would never work. In my experience, it often works. So call the patient, let them explain what they don't like, and if you can solve the problem. And one way to do it is to say, look, I now that I've solved your problem, I would appreciate it if either you would remove the review or update the review. It's a request, not a demand. And that language often is quite helpful. They're in the driver's seat. They can do whatever they want, but you're asking them nicely to reciprocate. You did them a solid, you want them to do you a solid. And you'd be pleasantly surprised. Frequently, that's enough. Not only will they often remove the review, sometimes they'll change a 1-star review to a 5-star review. I remember one where they were just unhappy with the way the practice did its billing. The doctor solved that problem, and then the the patient updated the review from a 1-star to a 5-star and said, "Dr. So and so listens, they really rock." That's a great outcome. Um, Sometimes you buy them off. I know that sounds like this is horrible. You have to take a shower afterwards, but in cash pay practices, where patients often pay a fair amount of money to get some type of service, it's not tremendously unusual for someone to be unhappy with the process or their outcome, and they are just expressing, or they're distributing their bile all over the internet and to the practice, and the doctor can't take it any longer. And they'll sometimes say, "Look, I'm willing to give you your money back if you'll take down the review and not post again." And in doing so, there's a settlement and release agreement. I know that one of the arguments is that you'll open up the floodgates if you do it for one. Thousands will come out of the woodwork, and you'll ultimately be forced into bankruptcy. That's actually not been my experience. I mean, for most practices, it happens once, twice, maybe 3 times a year. And for the most part, these are people where they recognize the red flag from the beginning, even before they operated on a patient. And with the benefit of hindsight, they probably should have said no to the patient, that they weren't going to take care of them or treat their condition. But somehow they slipped into the practice, and now they're just looking for closure. They just want an end to the unhappiness. And by either giving them some or all their money back, sometimes donating that amount to charity if both sides are well off and they're just looking for a way to resolve the impasse. There are plenty of ways to skin the cat. We do this all the time. This is a very common thing for me to do as an attorney. And the other question is, well, if they post anonymously, how will I know? How will I be able to hold their feet to the fire? And it just turns out they don't do it. Most of the time when they receive their payoff, they go away and never come back. Not always. Sometimes they come back a year later. They may have gone to a second surgeon, and the second surgeon throws you under the bus and reopens an old wound, and they forgot about this agreement, so they go online and post a new ugly review. I'll just send a note saying, "Look, remember a year ago you promised not to speak about the practice ever again, and here you've done it again. Dr. Segal honored his word. I'm hoping you will honor yours." And by the way, in the settlement and release agreement, it says that the doctor has the ability to claw back whatever he paid you and get his attorney's fees. And that usually is enough to get most people to take down their refreshed ugly review. So there are things that you can do. Let's assume that let's assume you don't want to talk to the patient, or there's no way to make nice. You can respond publicly, but you need to do so in a way that doesn't breach HIPAA. Without the patient's written authorization, you can't disclose any protected health information. So to the extent you're going to respond to the public, it needs to be done with proper care. You're not really debating this, and it's one and done. You're not going to go back and forth 5 or 6 times. You're not going to call them a name, but you're going to do it in such a way that you're educating the public going forward. So let's go through a couple of examples here. Here's one. Dr. X is a butcher. I had a facelift, developed an infection. My recovery took months longer than expected. Not a flattering review. I certainly would not want that up there. But this is a great response. And I would argue it's HIPAA compliant. So we're sorry anytime the patient develops an infection. The infection rate for this procedure nationally is 3%, but in our practice, it's 1%, far lower than national average. Still, our patients are not statistics. They either develop an infection or they don't. We will stand by any patient who has a complication and do our best to assist them with their recovery. What is not to love about this response? This is a marketing message where you've telegraphed to the public that you have a low infection rate, lower than your competitors, but it's not zero. And for a patient, their complication rate is either 0 or 100% to them. They're not statistics, they're individuals. They can only either have a complication or not have a complication. And here you've told them you will not abandon them. This is a great, I love this response, and it does not breach HIPAA. Here's another review. Dr. X is a butcher. He botched my facelift and now wants to charge me another $10,000 to fix his screw up. Again, not a flattering review. If I were that doctor, I would not want that up on the internet, particularly if it's not true. This is his response. Most of our patients are delighted with their outcome. We wish all were. Still, for those who are dissatisfied, we will offer to perform a revision within a reasonable time frame where we waive our professional fee. We offer to perform a revision within a reasonable time frame where we waive our professional fee. You've told the public how you solve problems, not that you're going to charge $10,000 to fix their screw up. You actually don't charge them anything, at least for the professional fee. So these are some notes. In that comment, there's no discussion as to whether the patient will be responsible for anesthesia. There's no discussion as to whether the patient will be responsible for the surgery center fee. And I don't even define, or the patient or the doctor didn't define what is meant by a reasonable time frame. But it does tell the world that complications do happen. You have a strategy for dealing with this, and it generally does not involve, double charging people if you cause the problem. And here, there's no back and forth debate. You're really just sending a message to the public. Arguably, it's a marketing message to the public. And in doing so, you've not disclosed any protected health information. One of my favorite adages is a surgical adage, which is the solution to pollution is dilution. What does that mean? It means that you are going to get an inevitable negative review. If you practice medicine, sooner or later, you're not going to make everybody happy. You're going to make someone unhappy, and they're going to have the time and patience to go online and post something ugly about you. But if you have a buffer of many positive reviews in advance of that challenging review, it will be diluted. I mean, having an occasional negative review and a sea of positive reviews is actually perceived as reasonable and good, sometimes better than 100% five-star reviews, because 100% five-star reviews may be perceived as marketing material. But having an occasional negative review, often accompanied by a HIPAA-compliant response, is probably better than just having 400 five-star reviews that have no text to them. They're just 5 stars, or good doctor, great doctor, love him. You don't need to go crazy over a single negative review. If you've got 450 positive reviews and a single negative review, I wouldn't worry about it. I mean, unless it's particularly damaging, you can always ask the patient to take it down using the strategies we discussed earlier. You can ask the review side to take it down if it breaches the terms of use. You can try to make the patient happy. There are plenty of ways to make this work, but if you are mostly positive, you really have to pick your battles. And the public already understands you're not going to make everyone happy. They just want to know that you make most people happy. And to the extent the patient experiences a challenge, a problem, a complication, you'll do your best to fix their problem, because they could be that individual down the road. All right, let's wrap up. So if you practice, you will eventually get a negative review. I'm a fan of trying to collect positive reviews before you get the inevitable negative review. The solution to pollution being dilution. And can you respond to negative reviews on the internet? You can, but you need to be cautious of HIPAA. So it can be done, but be careful. If, for example, the patient says, has their name and their picture on there and said, Dr. Segal was a horrible surgeon, and I write back, gee, Mrs. Smith, we really wish that you wouldn't have, smoked post-op. That's not going to work, because even though the patient is outed themselves with their name, you don't have their consent, you don't have their authorization to follow up on that. So be careful. It's possible to do it, but you need to tread carefully. There are only 2 ways to take down a negative review. Either the review site takes it down, or the patient does it. I'm not aware of any other way to get it done. Either the review site does it or the patient does it. And then finally, defamation lawsuits are expensive, capricious, unpredictable, and with the anti-SLAPP laws that are out there, It could add insult to injury, where you have to pay for the patient's legal fees. Not a good day. Well, I thank you for your attention. So the take-home message is be careful before you sue a patient for defamation. Thanks.